Now let's talk about price and other consideration. Price signifies the sum stipulated as the equivalent of the thing sold and also every incident taken into consideration for the fixing of the price put to the debit of the buyer and agreed to by him. Under the doctrine of obligatory force, the seller cannot unilaterally increase the price previously agreed upon with the buyer. Price must be real. We have learned that when the consideration is simulated, the contract of sale is void. But what about the principle of in Paradilikto, which provides that when two parties are equally at fault, the law leaves them as they are and denies recovery by either one of them? Well, this principle does not apply with respect to inexistent and void contracts. Now, what happens when the price is false, such as when the parties intended to be bound by the sale, but the deed did not reflect the actual price agreed upon? Here, there is only a relative simulation of the contract, which remains valid and enforceable, but subject to reformation. But what if the price was undervaluated in the contract to avoid payment of higher capital gains taxes? In this case, the price stated is false, but the sale is still valid and binding on the real terms agreed upon. Now let's proceed with the effect of non-payment of price. Sale being consensual in nature, the failure of the buyer to pay the price does not make the contract void for lack of consideration or simulation, but results in buyer's default, for which the seller may exercise his legal remedies, either specific performance or rescission. When price is neither certain or ascertainable, the sale is inefficacious. But if the buyer appropriates the object, he must pay a reasonable price. In one case, there was no meeting of the minds on the price, yet to deny the claim of the elevator service company would unjustly enrich the owner of the building who had benefited from the repairs of their elevators. Take note, however, that there is no appropriation to speak of when it comes to land. A definite agreement on the manner of payment of price is an essential element in the formation of a binding and enforceable contract of sale, without which the sale is void and an action for specific performance must fail. When the manner of payment of the price is discussed after acceptance, then such acceptance did not produce a binding and enforceable contract of sale. Now let's tackle the inadequacy of price. A simple inadequacy of price does not affect the validity of ordinary sales. When fraud, mistake, or undue influence is present, the contract may be annulled for vitiated consent, but not due to the inadequacy of price. Gross inadequacy of price may raise the presumption of equitable mortgage. It may also render voidable a judicial sale, when it is shocking to the conscience of men, and there is showing that in the event of a resale, a better price can be obtained, unless there is a right of redemption, in which case the proper remedy is to redeem. However, when the right of redemption has been lost, where the inadequacy of the price is purely shocking to the conscience, such that the mind revolts at it, and such that a reasonable man would neither directly or indirectly be likely to consent to it, the same will be set aside. So that's it for price and other consideration. Thanks for listening.